More machine guns in private hands. Sounds like a pipe dream, huh? Well, maybe not for long. A federal judge in Mississippi just declared the federal ban unconstitutional, at least for one specific defendant. This is the kind of news that makes me want to jump and shout hallelujah. Our anti-2A friends, though, they're not too happy about all this. They're now probably worrying about our arms race on Main Street. In this video, we'll talk about how this ruling came about, why it might shake up the status quo, and what it really means for you and me, and all pro-2A individuals who care about the Second Amendment. Let's begin by laying out the facts of this remarkable case. The judge in question, Carlton Reeves, presides in the Mississippi Federal Court, and the defendant, Justin Brown, was charged with unlawful possession of a machine gun. Judge Reeves ruled that the Federation ban on machine guns was unconstitutionalized as applied to Mr. Brown. This alone may sound like an earth-shattering development, but remember that this is a ruling specific to one individual defendant in one criminal case. That means this does not automatically wipe out the entire ban for everyone. Still, it's a small crack in what is supposedly an impenetrable anti-2A wall, and cracks have a habit of spreading if the foundation is weak. How did Judge Reeves arrive at this conclusion? Let's rewind a bit. Everything hinges on the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruen, which sent shockwaves through Second Amendment jurisprudence. Bruen maintains that the right to keep and bear arms is tied to our nation's historical tradition. Gun regulations now have to pass what's called a historical tradition test. In plain English, if the government wants to restrict your ownership of a particular firearm, they need to show that a similar law with similar purpose existed historically in the United States at a time close to the founding. Because that's when the Constitution was written, and that's the tradition the court supposedly want to preserve. Judge Reeves took this instruction to heart and stated that based on the evidence before him, the ban on machine guns failed to meet that criteria. Here's the wild part. Judge Reeves also admitted he didn't personally agree with the Bruen framework. In his written opinion, he openly expressed his belief that looking for analogous 18th century or 19th century laws to justify or invalidate modern-day legislation can lead to absurd results. Yet he explained that his hands were tied. Since Bruen is the law of the land, he saw no choice but to apply the historical tradition test as directed by the Supreme Court. And under that test, he found that the government had not proven machine guns are so unusual as to be unprotected. The exact phrasing, dangerous and unusual, first pop up in District of Columbia versus Heller, another Supreme Court case. While everyone accepts machine guns are dangerous, Reeves focused on whether or not they're truly unusual in the sense of being outside the mainstream of civilian arms use. The government in Brown's case presented arguments that machine guns are in fact unusual because they have been heavily restricted by federal law since 1934 under the NFA and even more so after the 1986 Hughes Amendment. But that argument was slammed by Reeves as circular reasoning. A weapon can be considered unusual solely on the basis that its ownership is already restricted by the very laws that are being challenged. Imagine trying to justify a ban on a certain type of dog by saying, well, hardly anyone owns that dog, when the reason no one owns it because it was banned in the first place. It's a bit like chasing your own tail, and it doesn't carry much weight under Bruen, which demands genuine historical analogs rather than modern statutes. Another pivotal fact was the sheer number of machine guns in the United States. In earlier cases like Hollis versus Lynch, the Fifth Circuit cited roughly 175,000 transferable machine guns, concluding they were too few to be in common use. But in Brown's case, Judge Reeves found a record showing approximately 740,000 machine guns, potentially combining legal and illegal ones. He concluded that the government had not disputed that number, and if 740,000 exist, can we truly call them unusual? That's essentially the question he put on the table. It's a staggering figure, and it gave him a reason to say, "Look, these firearms are out there in substantial numbers, so calling them unusual doesn't line up with the evidence before me." Now, it's important to emphasize that Brown's ruling currently applies only to this single defendant. If you're thinking about running out and adding a shiny new M16 or M249 to your collection, hold your horses. The broader ban is still in place. However, this sets up a potential showdown on appeal. The federal government can appeal to the Fifth Circuit, and we all know the Fifth Circuit is widely regarded as one of the most conservative appellate courts in the country. You might guess that means they'll come down strongly against the ban. But let's not jump to conclusions if the case goes up. The Fifth Circuit will have to reconcile this new analysis under Bruen with its previous rulings, such as Hollis versus Lynch and the United States versus Simeon, both of which declared machine guns as unprotected under the Second Amendment. Let's now reflect on how we arrive at a place where machine guns are so controversial. The modern restrictions date back primarily to the 1934 National Firearms Act, a piece of legislation enacted during the gangster era. We all know those iconic black and white photos of people like Al Capone, the Thompson machine gun, aka Tommy gun, slung around. Congress decided to heavily regulate such weapons, introducing a tax and a registry. Then in 1986, through the Hughes Amendment, the government effectively froze the supply of new machine guns for civilian ownership, grandfathering only those manufactured and registered before a certain date. This created a bizarre secondary market where legal machine guns often cost tens of thousands of dollars because they can no longer be newly manufactured or imported for civilian use. Under Bruen, though the question isn't whether politicians felt threatened by gangsters or whether mass shooters might cause chaos with a machine gun, it's whether there's a strong historical tradition of banning or restricting a certain firearm to the extent that the modern law is a direct descendant of that tradition. And here's where it gets tricky for the government. There just isn't a robust record of the founding fathers banning certain kind of guns in the 18th century. Muskets and cannons could both be owned by private citizens, and while technology has come a long way since flintlocks, the Second Amendment doesn't mention limiting you to archaic weaponry. The question is whether the Constitution protects your right to own something on par with what a modern soldier might carry. After all, back then, a militia member's personal firearm was in many cases the functional equivalent of the infantry's musket. Judge Reeves' ruling dials right into that line of logic. If the government wants to justify banning machine guns, it must point to historical regulation that did essentially the same thing at a relevant time in America's past. The government didn't produce much in the Brown's case, so the judge tossed out the ban for this defendant. To some, one might sound radical, but to those of us who believe the Second Amendment means what it says, that a well-regulated militia requires citizens to have arms suitable for militia use. It's logical. Machine guns, particularly the M16 and its variant, are the standard rifle for our armed forces. If you want an individual rifleman weapon, that's it. Many interpret that as exactly what the Second Amendment is supposed to protect. Yet, there's also political and cultural dimension we can't ignore. Even among staunch supporters of gun rights, the full auto line has traditionally been treated as the outer boundary. People talk about AR-15s and magazine capacities, but rarely do they delve into M16s or M249s with the same fervor, because the law have been in place for so long that everyone basically accepted it as a done deal. With Brown, that comfortable acceptance is suddenly less certain, and it's downright exciting for anyone who thinks the Second Amendment is about more than just hunting rifles and concealed handguns. Now that said, we can't forget the reality of the courts. The Supreme Court has been reluctant to openly say that machine guns are protected by the Second Amendment. Even in Heller, Justice Scalia hinted that certain restrictions, especially in weapons like machine guns, would remain presumptively valid. But Bruen shifts the framework from what had been a two-step balancing test to a purely historical approach. The ramification of that shift could open the door for arguments that the M16 is simply the modern equivalent of the musket, and that if the founders didn't ban muskets, then neither should we ban the M16. Whether the Supreme Court will ever affirm that, logic remains an open question. But at least now, there's credible paths for attorneys and defendants to argue it. What does this mean for everyday gun owners right now? Practically speaking, if you're a law-abiding citizen, you're still under the same federal restriction as before. The ATF is not going to let you register a brand new post-1986 machine gun, nor are you going to walk into a gun shop and see belt feds line up for sale to the average buyer. However, if Bruen is upheld on appeal, and that's a big if, then the Fifth Circuit would be charting a new course on machine guns under Bruen. That might create a conflict with other circuits, or even with previous Fifth Circuit decisions, which could tee this issue up for Supreme Court review down the line. If you're looking for more immediate impact, consider how this logic might spill over into other forms of firearm restrictions. Suppressors, short-barreled rifles, and certain assault weapon bans might come under intense scrutiny if courts continue to apply Bruen as rigorously as Judge Reeves did. It could lead to a wave of cases where the government struggles to produce historical analogs for modern firearms technology. And from a Pro-2A standpoint, that's fantastic news because it puts the burden where it should be, on those who wish to limit our rights, rather than forcing law-abiding citizens to justify why they should be able to own a particular weapon. The government must show that such a prohibition traces its lineage to the founding era. It's fascinating to imagine the day when the Supreme Court have to address whether an M16 or an M14 is protected under the Second Amendment. The same logic that says you can own a semi-automatic AR-15 could easily support the view that the only difference between that and a select-fire M4 is an extra feature switch. If the principle is that civilians ought to have access to the standard infantry weapon of the day, then the M4 or M16 is the obvious winner. Yet, the majority of people, normies or sentries, or whatever you want to call them, would find that concept terrifying, as they equate machine guns with unstoppable carnage. The rejoinder from our side is that criminals aren't exactly abiding by these bans anyway. The truly determined bad guy can build illegal full auto conversions in a home workshop, which is why bans disarm the good guys while leaving the bad guys armed. Another angle that Judge Reeves' ruling highlight is the possibility that existing numbers of a certain type of firearm in circulation can serve as a proof of common use. If the courts ultimately confirm that the aforementioned 740,000 is indeed a large enough figure, that's going to raise interesting questions about other categories of weapons or accessories. How many short-barrel rifles or brace pistols are out there? How many so-called assault weapons exist nationwide? Some estimates place under the number of AR-15s in civilian hands in the tens of millions, which is clearly not unusual. That definitely boosts arguments that AR-15 bans are unconstitutional. And if anything, you could say fully automatic rifles might follow the same logic, albeit at smaller overall quantities. Right now, a big question remains. Will the government appeal? They might fear that appealing the Bruen decision and losing would set a binding precedent across the entire Fifth Circuit, covering Texas, Louisiana, and Mississippi. That could make the government's job of enforcing the ban even harder. Or they might feel compelled to appeal to protect the national framework prohibiting new machine guns, if they think the Fifth Circuit conservative leanings might lead to a reversal. That could be a risk they're willing to take. After all, historically, the Fifth Circuit has shown it's no pushover on issues like this. But Bruen is new, and we don't entirely know how it will reshape the circuit's thinking. It's a gamble. Until then, the rest of us can only watch closely because we're witnessing a potential pivot point in Second Amendment law. But that's all the time we have for this video. If you want to stay up to date on this potential appeal, future developments, and more news that matters to the gun community, then we have a small favor to ask. Please like this video, share it with your friends, subscribe to our channel, and click on the bell icon for more of these videos. Your support means the world to us. Thanks for watching, and we'll see you again soon.